If you want to know the latest about the Chevy Bolt battery recall, its legal ramifications, and what kind of compensation that you may be owed, stick around. And make sure to watch until the end, where I'll give you 3 important steps that you should follow to maximize how much compensation that you may be owed. Really quick, my name is Sina Rezvanpour. Not only am I a big car enthusiast, but I'm also a lemon lawyer, which means that I get to have a great time helping people with their car trouble get compensation under the lemon law. Let's get started with the quick history lesson on the Chevy Bolt. The Chevy Bolt was and still is an incredibly popular car, and a car that many Bolt drivers still love despite the very public issues with the Bolt's battery. The Bolt was first developed in partnership with LG, and sales started in late 2016, and it had instant success. At one point, it was Motor Trend's Car of the Year, and Time magazine named it as one of its best inventions. For a few years, things were great, until in November of 2020, over 50,000 Chevy Bolts were recalled due to potential fire risk. These were 2017s, 2018s, 2019s, all that were produced in the Ochang plant. The reason for this recall, as most of you know, is that the affected Bolt's high voltage battery were prone to catching on fire when the vehicle was charged to full capacity or nearly to full capacity. And while you weren't seeing Bolts on fire left and right, there was a real danger, and there still is a real danger, that some of these vehicles would go up in flames. GM advised Bolt customers to avoid fully charging and to not park close to structures. This was a huge inconvenience, to say the least, and was much easier said than done for many people who relied on the Bolt's range and often had a hard time parking their vehicles, whether it was at home, whether it was at work. So what did GM do? Well, in November of 2020, they told Bolt drivers to manually limit their charging capacity and to bring their vehicle in for battery replacements. Except there was one big problem. Those battery replacements were not yet available. Months later, in May of 2021, GM then launches its first software update that is meant to address the battery, but the update is largely unsuccessful. The software update limited charging and range and was very obviously a band-aid on what proved to be a major wound. In September of 2021, GM finally announces that it will begin battery replacements on 2017s, 2018s, and 2019 model Chevy Bolts. Fast forward to 2023, and not only has GM ended the Bolt line, but they are making it incredibly difficult to get a battery replacement, especially for 2020 newer Bolts. Instead of battery replacements, which is what everyone is looking for, GM has announced that for 2020, 2021, and 2022 model year Bolts, they are eligible, as if you should be thankful for this, for a new diagnostic software that will monitor the battery in lieu of an actual battery replacement. This has rubbed many Bolt owners the wrong way. Now, while I myself don't own a Bolt, I have helped hundreds of Bolt owners and hundreds of Bolt lessees in their lemon law claims. And from my perspective, I saw that GM was doing the right thing in almost all cases. They were moving slowly, but they were doing their best to address people's claims, doing what they could to clean up the mess that the battery defect caused. However, with their latest move, and by that I mean the new diagnostic software, I feel as if GM is just over it. They are over trying to keep people happy. They are absolutely over the Bolt. They are absolutely overdoing battery replacements. And in many cases, they're actually going so far as to tell consumers that they're actually not entitled to compensation. Or they're saying that they are owed less compensation than what they truly deserve. And to me, that's just not right. By the way, I know it's not the subject of today's video, but there was also a more recent recall related to the seatbelt pretensioner. And believe it or not, the issue with the pretensioner can also cause the Bolt to catch on fire. This is because the pretensioner, it uses a small controlled explosive charge to tighten up the seatbelt at the onset of a crash. However, the hot exhaust from this very small explosion can cause a fire on the carpeted surfaces of the vehicle. So if you own or lease a Bolt, what can you do? Well, there's 3 steps that you need to follow. Number 1, call up your local dealer and make an appointment to perform any open recalls. While you're there, make sure to also know any other issues or problems with the car that are covered under warranty so that you can get everything fixed at once. And this would include the seatbelt recall I mentioned just a moment ago. Why is this step necessary? Well, it's because each state's respective lemon law will require you to present the vehicle to the manufacturer to give them a shot at repairing the vehicle. This not only shows that you're taking the issue seriously, but that you're also taking your safety seriously. Number 2, after the dealer has had a chance to work on the car, I want you to contact GM and I want you to ask them for a buyback of your vehicle. I'll make sure to put a link below in the video description to GM's contact page. And what I want you to do is I want you to reach out to their customer support, whether it's by phone or by chat. My personal preference is to reach out by chat because then you have a written record of the conversation and there is no misunderstanding. Once you get connected to a customer care rep, I want you to let them know that you are requesting a buyback of your Bolt because of all the problems that it's faced, whether it's the battery or other issues. Your claim will next likely be assigned to a team that's specialized in your state's lemon law. For example, if you leased a vehicle in California, you're going to get assigned to the California team. By the way, make sure that if you're communicating with GM on the phone, keep some decent notes on the conversation and pay particular attention to whether you've been assigned a case number. That's going to be important later. If you're communicating with them via chat, then what I want you to do is do your best to either copy paste the body of the chat or download it if it's possible and save that in another file just so that you have that in a safe place. This next part is where things get spicy. I am predicting that based on what I've seen on hundreds of previous cases, the GM will either deny your request or fail to honor your request in a timely manner, as they are required to by law. If they did this wrongfully, which in many cases they do, you will very likely be entitled to more compensation than you would have before you made this request. This is because in many states, take California for example, the lemon law allows you, the consumer, to recover additional damages, that means money, if the manufacturer has intentionally violated the lemon law. On this slight chance the GM offers to buy back your vehicle and they do so in a timely manner, then great, they did everything right and you are free to accept or to reject their offer. So really, you have nothing to lose by taking these very simple steps, and it should only take you a few minutes to complete. By the way, you are in no way doing anything wrong or unethical by contacting GM. In fact, you're doing the opposite. You are giving them a chance to do exactly what the lemon law says that they should do. They are supposed to buy back your vehicle in this situation, and you are giving them the opportunity to do this before there are any lawyers involved, before there's any court involved, before things really get complicated. Step number 3, if you've completed the first 2 steps and GM has denied your buyback request as I predicted, I want you to contact a lemon lawyer. Now, obviously, I'm a little biased and I would suggest that you contact my firm since the majority of our cases are for the Chevy Bolt, but I will leave that choice up to you. A lemon lawyer can help you get back the compensation that you deserve before you even contacted GM. And they can also help you get additional compensation, often referred to as a civil penalty for GM's failure to buy back your vehicle. At my firm, we have done exactly this hundreds of times, and a common question we get asked is, do I have to give back my vehicle if we settle the case? And the answer is, thankfully, absolutely not. GM would be more than happy to compensate you for your problems, compensate you for wrongly handling your claim, and pay your attorney's fees, because remember, under the lemon law, the manufacturer has to pay your attorney's fees. In other words, GM would be more than happy to offer you what we call a cash offer. That means not a buyback, compensation without buying back your vehicle. If it's absolutely important to you for them to buy back your vehicle, then of course we can help with that as well. There is plenty to discuss here, so I may have missed some things, especially on the Bolt's history, especially on some questions that maybe I didn't think of answering. So if you have those questions, make sure to drop them below. I will leave a link below where you can contact our team if you would like to continue this discussion. If you found this video helpful, make sure to give it a like, share it with another Bolt driver, or share it in a message board with Bolt drivers. My name is Sina Rezvanpour, and thank you for your time.